So it was a woman in the chat that said that she's on day 18 with no court-appointed attorneys. She's had no visits, no calls, nothing. And her question was, how can they do this?
Okay, we're back. I'm attorney Vince Davis. This is The Secret, How to Fight CPS and Win. I'm with my co-hosts, Amanda Cisco and Brian Hamilton. Hey, Brian, you private messaged me and Amanda during the last segment about a question that was posted. I saw that question, but, you know, as the questions were coming in and I was talking, I lost track of the question. What was the question that you saw that you wanted to discuss?
So it was a woman in the chat that said that she's on day 18 with no court-appointed attorneys. She's had no visits, no calls, nothing. And her question was, how can they do this?
Okay, so assuming that she is in California, and if she's in another state, different laws may apply, but, you know, I'm pretty sure they're going to be similar or, you know, strongly similar since they're all based upon federal regulations of the Department of Health and Human Services. When your children are detained from you, under California law, you're supposed to have a visit within the first 48 hours. And you're supposed to have a hearing, your first hearing, within 48 to 72 hours. The law actually says 48 hours, but there's a California appellate case that gives them up to 72 hours to have their first hearing. Now, if you go past that, they may not be filing a case, or they might have changed their mind and just, you know, decided to X you out of the, you know, the picture. I had a case many years ago, maybe 4 years ago, of a woman who they had taken her 2 children from her, and they told her they were going to file a case, and the day of the case that was supposed to be heard, they decided not to file the case. But they kept her children, and they put her children in foster care with a relative, but it was a relative she didn't really know. And they kept her children away from her for over, I think, 7 or 8 months without filing a case or anything. You know, it's just, hey, we're taking your kids, we're placing them with a relative. They did get her to sign a piece of paper to try to agree with it, but she, within a couple of days, revoked that, which she could at any time. And then the social worker would have had to go back to court to get a court order to keep her kids away from her. Anyway, we brought a civil rights lawsuit on her behalf, and we were able to resolve the case in her favor and in her children's favor because they had been kept away from their mother for so many months without a court order. So, you know, it amazes me sometimes what social workers will do. And you know, I'm always wondering, you know, they receive such high training or such, you know, good training supposedly, that they still do things like that. So to answer the question directly, no, they're not supposed to be able to do that. Now, there might be some weird circumstance that I don't know about or don't, you know, about the case because she just asked a question without any factual background. But just answering that question, no, they can't do that. She's supposed to have visitation. She's supposed to go to court, you know, within 72 hours if the case is in California. And then that's that. Now, you might get to court and the judge might say, no visits for you, right? That happens in rare circumstances. Usually the judge will give you visitation, but it's going to be monitored or supervised by someone, right? But you got visitation. It's not like you haven't seen your kids in how many weeks did she say? 18 days?
18 days, yeah.
Yeah, that's way out of bounds. But I've heard people say that before. You know, they get lost in the system. Social worker gets busy. Social worker, you know, may retaliate for some reason, but it's not supposed to happen. So I hope that answers that question. Were there any other questions you guys wanted me to address in the chat before we go on our first hour break?
I was interested in a comment that you said. Can they legally detain your children without filing a case?
It's a very gray area. They can detain your children if they have a court order, a warrant, or exigent circumstances. Okay.
Okay.
Once they do that, they're supposed to file the case and have a hearing within 48 to 72 hours. Now, what happens sometimes is they say, "Oh, we're not going to file a case," and then they don't give you the kid back. I just talked to someone where that happened, and they didn't. They left the kid with the non-custodial parent, the father. So they were trying to execute a change in custody without going to court, and that of course is a no-no. But Amanda, when you say can they legally do that, that's not the right question. The question is, do they do it? Yes. Do you have remedies to to punish them for doing something that they don't have a legal right to do? Yes, you can do that. But can they do it? These people do anything they want to do. And sometimes they have the facts to support it. Sometimes they don't. I hear a lot of people tell me, "Oh, Mr. Davis, they're making, stuff up."
I really wish that judges would require more evidence from these social workers before making a decision to allow a child to be removed from their parents.
Well, hold on a second. It's not the judge's job. The legislature has written the law, and depending on what hearing it is, sometimes it doesn't take a lot of evidence to keep the kid away from you. That's the law. That's not the judge's decision. Judges usually decide issues, disputed issues of fact and disputed issues of law. They don't make up the law. And see, what your real complaint is not with the judge. Your real complaint is with the state legislature there in Virginia or in California or whatever state you live in. People always tell me, "Oh, the judge is corrupt, blah, blah, blah." And I say, well, what happened? And it wasn't corruption at all. It's just that it's the way the law is written. And that's why I tell people, hey, you know what? You want some real reform? You need to vote in new legislators. Yeah, you can vote for judges and stuff, but that's not going to really help because presumably judges are implementing the law as it's written. Now, you may not like their decision, right? But that's not the judge's thing. That's the legislature's thing. Like in California, when you have a trial, you don't get to have a jury, right? And I think it's the same in Virginia.
2 minutes.
Same in a lot of states. But in some states, you do have a right to have a jury trial. That's not up to the judge. That's the state legislature who's decided we're going to set aside, millions and millions of dollars so that people can have jury trials. So you see how the competing interests weigh your right to be judged by a peer group versus all the taxpayers paying more money so that you can have that jury trial. I don't know if it was you or who I was talking to about the economic analysis of the law. When I first was that you?
Mm-hmm.
Okay, so when I first got to law school, my first year, one of the most recommended books, and you see it quoted almost in every class in law school during your first year, is called Posner, The Economic Analysis of the Law. Economics has so much to do with the analysis of the law that, it shocked me. I thought I was going to law school and we're going to do what's right, what's just, and what's good for people. You think that, but that's not what the law is. The laws are based upon what state legislatures decide. And then the judges just, decide issues of disputed fact and law. They don't make the law, although it seems like it sometimes because they make decisions that you don't like. But you got to start with the laws. You know, if you want to change something, let's change laws. Okay, we got to take a break right now. This has been The Secret, How to Fight Child Protective Services and Win. We're going to be right back after this news break and these commercials with more calls and more questions.